thank you to be here for the last panel of the 2 days, the student panel. It's a pleasure to welcome, I just follow the order of the program. First, Aurore Troussel. After that, we will have Mubarak Nurudeen. And at least Adrià, I need my glasses, I'm sorry. Even if I use larger characters. Adrià, Medina, Altarriba. What is interesting with these two students, all of them come from different countries. In the case of Aurore, she came from France. Mubarak come from Nigeria. Adrià come from Catalonia. But they study in different countries. In the case of Aurore, she studied here. And in Belgium, I think. Mubarak is doing his master degree in US, and in the case of Adrià, he's doing his LLM in Iceland, which is quite exotic for us. And but all of them, of course, dealing with ODR, with AI. All of them also propose a very practical perspective and consider very concrete tools about AI. And all of them have a different, has a very general vision of law. We don't speak about law, but we're in the case of Aurore, you're dealing with technical norms. In the case of Mubarak, I saw the terms of governance. And Adrià is proposing a flexible approach of certification. So law is now very broad. We need to see law in the very broad visions. And I don't want to take so much time. Each panelist has between 12 and 15 minutes. I will be the master of the clock. And if you respect the time, for sure we have maybe 10 or 15 minutes for discussion with the audience. So please, first, thank you, Aurore.
Okay, so thank you, Vincent, for this introduction. Hello, everyone. Today, I will present briefly a comparative study that I did on ChatGPT 3.5 and LegitGPT. So the idea is that I prompted those two models just to see whether they could help lay people in resolving a dispute. So the agenda is a brief presentation of ChatGPT and LegitGPT. Then I will present my methodology and the prompt engineering techniques that I used. And I will present the comparative study that I ran on 3 aspects in relation to dispute resolution. So I won't present ChatGPT because time is running, but LegitGPT is a French tool which is based on ChatGPT 3, and it's really focusing on the legal domain. So LegitGPT has been trained on almost 150 articles of law coming from all French codes. And I think that it has been trained until April 2022, so it's almost up to date. Regarding the methodology I used, so I decided to select one use case so that I could test the two models on a specific use case, which is a neighbor dispute between Alice and Bob. And Alice is complaining about the rooster of Bob, who is yelling all day long. So she will try to resolve this dispute with Bob. And I asked 3 questions to the two models, ChatGPT and LegitGPT, asking them some help. So you will see the question later. And I'm comparing the answers of the two models with a legal perspective, because I have a law background, but also from a lay people perspective. Then I evaluate the answers based on 5 criteria, which I tried to find objective criteria, such as does the answer contain errors, legal errors, but also more general errors in relation to the limitation of the model as such, and also, for example, the reference to legal articles and those kind of criteria. Then regarding the prompt engineering techniques that I used, I would say that I used those two models as a super bad prompt engineer, because I was constrained by the prompt limit of LegitGPT, because LegitGPT only allow you to prompt it with 300 characters, so approximately 50 words. So compared to ChatGPT, I couldn't really draft good prompts with very specific tasks, with context and those kind of prompt techniques which are usually advised when you use a large language model. And also, I reloaded each conversation with the models so that each time I ask a question, the model won't refer to the previous question and the previous answer. And it's very important in terms of the result that we can get. So I only gave a few elements of context regarding the dispute, such as basic facts, the nature of the dispute, and the identification of parties. Also, I gave no legal information and super broad instructions. So regarding the first aspect in relation to dispute resolution, I focused on the creation of a mediation process. So I asked ChatGPT and LegitGPT, can you create a mediation process in several steps? So it's a super broad instruction. And ChatGPT gave me a mediation process composed of 5 steps and a follow-up stage. So the steps were quite similar to what we found in usual dispute resolution, and I found it quite superficial, but still it was really something that could have worked, I think, between 2 parties. So it was informative. Also, ChatGPT at the end of the answer provided a disclaimer saying that the mediation process could really vary depending on the dispute at stake. And he also did a reminder regarding the role of the mediator and the fact that the mediator should be neutral. LegitGPT, on his side, provided a 6-step mediation process, including a follow-up, and the mediation process was, I would say, of a better quality, much more based on, I would say, the legal knowledge of the model. And also at the end, he also provided a disclaimer saying that we should always refer to the applicable law. And he also advised to consult a legal professional. So regarding the 5 criteria that on which I'm basing the comparison, so regarding the word counts, the answer provided by LegitGPT is longer than the one of ChatGPT. That's also why I found his answer more instructive. None of them referred to legal articles. They both referred to legal principles, such as the neutrality of the mediator and the need to have open discussion, for example. So I found this quite interesting. Also, LegitGPT made one mistake, because, for example, in 2 different steps of the mediation process, he was a bit redundant, saying you should do this, you should do this. So it was a mistake from the model as such. So the winner on this task was, in my opinion, LegitGPT. Then I also evaluated the 2 models on the evaluation of the dispute. So as you can see here, I prompted them saying that you are the mediator in a neighbor dispute between Alice and Bob. Alice considers that Bob's rooster is causing her an abnormal neighbor disturbance because of its squawking. So Alice asks Bob to get rid of his rooster, but Bob refuses. Help them find a solution by referring to the applicable law. So here I introduced the reference to applicable law because I wanted to test the models on their ability to provide legal advice, even if it's not, it shouldn't be the role of a mediator in most of our mediation, as we know them. So regarding this, ChatGPT said that it depends on the applicable law, and he provides 6 general advices, including doing a mediation, for example, but also more practical advice, like you need to discuss with your neighbor and stuff like this. And she said that in the end, the solution of the dispute will depend on the applicable law, but also on the evidence that Alice could find to prove that the rooster is really making too much noise. And he also advised to consult a lawyer. On his side, LegitGPT did a very structured analysis of the case by referring to the applicable law. So he picked up the good article in the French Public Health Code, and then he explained that regarding the fact, it might be interpreted in this way. So he did almost a legal syllogism, which was correct, I think. And also he did a proportionality assessment, trying to know whether the rooster's noise would be at a higher level than what the law is allowing. And also he proposed practical solution and innovative legal reasoning, because he even picked up some legal articles for other code, protecting, for example, agriculture and farmers. And I found this quite interesting because it was a kind of complex legal reasoning compared to what we could have done as a law student or even as a lawyer. And also he used first the general rule, and then he tried to find exception to this rule, so as we can do as a lawyer. Regarding the criteria, so the length of the answer were almost the same between the two models. They provided a quite long response with a lot of information, so I think it was a good point. LegitGPT referred to 3 articles. The main article, which was related to the prohibition of excessive noise, but also this article in relation to the protection of farmers, and another article regarding the procedures. The thing is that he made mistakes when he interpreted this article about procedure, because he said that, for example, mediation should be at the initiative of parties, while in French, on this specific kind of dispute, mediation is mandatory. So here he provided a wrong legal advice, so I think that this is also interesting to mention this. And both referred to legal principles such as neutrality, proportionality, and they presented no sign of partiality, I think. So here my winner is LegitGPT because he referred to legal article, but in the end, as he gave a wrong legal advice, I'm not sure that we have a winner on this specific task. And yes. So on the last aspect, I tested those 2 models on the ways they could help lay people to resolve a dispute. So here I prompted them as if I were Alice. So I said, my neighbor has a rooster that croaks from night to morning. I can't sleep. I'm very sensitive to the noise. And since the rooster arrived, I don't feel at home. My neighbor refuses to get rid of the rooster. What can I do about it? So here you see that I really don't refer to mediation or law or anything, so it's an open question. And interestingly, ChatGPT replied and provided 6 steps and general advice. And among those general advice and he gave practical solution like sound insulation, discussion with your neighbor, and also legal solutions such as mediation or asking the advice of a lawyer. He also advised to stay calm and respectful, and the final solution, according to ChatGPT, so if all his advice fail to help the Alice solving the dispute, he advised to put in place sound insulation system. On the other side, there is LegitGPT, who is proposing 4 legal options or steps going from mediation to court. So in the end, we see that the final solution proposed by LegitGPT is to go to court. So he also says that we should consult a legal professional, but in the end, he will advise Alice to go to court with this claim of a rooster making too much noise. So here I consider that LegitGPT, again, doesn't give a good advice, because I'm not sure we should go to court for a rooster. So that's also an issue. And at the end, LegitGPT reminds that finding a peaceful solution is important. Maybe that Alice shouldn't kill the rooster or something like that. And so on the objective criteria, the answer of LegitGPT was again longer than the one of ChatGPT. He referred to 2 legal articles which were correct. One regarding the substance, so the fact that the neighbor shouldn't make too much noise, and one regarding the procedure. He just advised Alice to see whether police forces could intervene. Voilà. And then I think that implicitly we could say that ChatGPT referred to the legal principle of fairness, because really the way he tried to help Alice resolve this dispute was really fair. I think he was trying to promote a fair solution to this dispute. regarding the errors, I would consider that LegitGPT made an error if he advised Alice to go to court for this dispute, because I also analyzed the applicable law and the case law in France, and according to the case law, she would probably lose this dispute. So I'm not sure that it's an error as such, but still it's problematic. And finally, signs of partiality, I found that LegitGPT was quite partial, meaning that he was convinced that Bob was guilty, while I never said this in the prompt, and it's not sure in real life that, that Bob is doing something wrong with his roster. So I would prefer my neighbor not to use ChatGPT. I made a mistake. Not to use LegitGPT because he would advise to go to court. So one fun fact about this is that when I asked ChatGPT, when I didn't ask ChatGPT to act as a mediator, he said, be sure to remain calm and respectful in your interaction with your neighbor, as open communication and the search for mutually acceptable solutions are often the best approaches to resolving this type of conflicts. So I found this super interesting that this general chatbot is just providing the kind of advice we could provide as mediator. And on the other side, I say flow fact because LegitGPT really started. First of all, it's important to know that your neighborhood noise is regulated by law, and then he advise you to go to court. So in the end, this legal LLM would maybe provide legal advice based on the law, but still, if we think about access to justice and resolution of dispute, it might not be an appropriate tool because it's too procédurier, as we say in French, which is ethically questionable when you are providing advice. And the deep thought before this analysis is that I prompt so am I, and so AI as well, because the way you prompt is really the way you think about a dispute and the way you frame it. So it's very important to think when you prompt that you will influence the output of the model. But it's also the way you prompt, the way you create yourself the output generated by AI, which means that if I'm prompting an LLM in a particular way while giving information, for example, I will influence the way it reflects about what I'm asking for. So voilà, we prompt what we are, and AI is what we prompt. So thank you. I'm happy to discuss, and it was a bit a superficial presentation, but if you are interested in having the prompt, the output, and the study as such, you can email me at this address. Voilà.
And thank you to respect your time. You still have 5 seconds, so that's just perfect. And please welcome Mubarak Nurudeen. I was very quick to present him a few minutes ago, just to do the change, but he is actually a student at the Ohio State University, and also 15 minutes for your presentation.
Yeah, thank you very much. Good afternoon, everyone. It's indeed a pleasure to be here this afternoon to present before this community of experts. Although I'm not an expert, I'm just a student, and I would like to share with you a research work I have conducted in the past few months. Yeah, but before I proceed, let me especially thank Professor Amy, who has instilled the love for ODR in us at the Ohio State. Yeah, I thank you so much. Yeah, so before we delve into the presentation, I would like us to take a look at this short video for the next 2 minutes or thereabout.
Over the last year and a half, a lot of us who work in offices have gone remote. And while I miss seeing the people I work with, I think remote work is here to stay for a lot of people. So we're going to need better tools to work together. Let's take a look at what working in the metaverse will be like. Imagine if you could be at the office without the commute. You would still have that sense of presence, shared physical space, those chance interactions that make your day all accessible from anywhere. Now imagine that you have your perfect work setup and you can actually do more than you could in your regular work setup. And on top of all that, you can keep wearing your favorite sweatpants.
Looking good. Let's get together real quick for a debrief.
I'm free now. Let's jump in. Hi.
Hey.
So what do we think?
think it's ready.
Great.
I'll prep it for the presentation.
All right. Good luck.
Imagine a space where you can tune out distractions and focus on the task at hand. And when you're ready to share what you've been working on, you can present it as if you're right there with the team.
Wait, where's Mark?
I think he's in the middle of something.
All right. Okay, thank you so much. Yeah, so let's get started. I have the outline, and then now let's begin. So, the past few years, the growth of technology has been quite fast-paced. So, the pace is actually expected to continue given the fact that the development of one technology stimulates the creation of another. And then also in the past few years, we've seen the gradual shift from physical interactions to virtual interactions. And in the heart of these virtual interactions is where we have the metaverse, which is a form of virtual interaction. We saw people move from physical interactions to virtual interactions during the COVID-19 pandemic. But then the thing is, unlike the regular social media that basically discourages people or perhaps prohibits people from encouraging in some sort of commercial activities or business activities, the metaverse actually allows commercial activities to thrive. People work in the metaverse, people transact businesses in the metaverse. We've had brand designers actually open stores in the metaverse. So the metaverse economy is actually thriving and developing. There's a whole lot of traction, and there's been a lot of surveys around the metaverse. It is predicted that by the year 2030, the metaverse would be worth around $5 trillion, which is actually equivalent to the economy of the third world largest economy at the moment, which is Japan. So in essence, there's a whole lot of traction in the metaverse. And at the heart of this interaction is that disputes are bound to arise. And then the question that we begin to ask ourselves is, what is the appropriate dispute resolution mechanism for the resolution of these disputes? Are our conventional courts sufficiently equipped with the facilities to resolve these disputes? Are our judges, or do our judges possess the requisite expertise to adjudicate in this kind of dispute? So those are the form of questions that arise. And in our interactions, we will see issues like intellectual property, antitrust, even consumer and employment claims arise from the series of interactions in the metaverse, and breach of contract issues, sexual harassment claims against one avatar against the other are the kind of dispute that are bound to arise in the metaverse. So let us conceptualize some concepts before I proceed. We have the avatar, we have the virtual reality, we have the ODR, and then the metaverse. So basically, the avatar is a graphical representation of a user in the metaverse. So I like to relate the relationship between a user and the avatar to the relationship that exists between a director of a company and an incorporated entity. So it's basically a sort of an alter ego relationship. So the user has its representative in the metaverse. So the user can actually design the avatar in the metaverse to look like him graphically, and then they can also have similar looks. So we have virtual reality, which is basically simulation in the 3D environment. We have ODR, and then the metaverse, which is basically a space that allows you to interact with computer-generated environment and then other users as well. Now, let us look at a brief historical background of the metaverse. The metaverse is not new. The concept of the modern day metaverse that we have actually emanates from the work of a science fiction writer, Neil Stephenson, who in 1982 wrote a book, Snow Crash. But prior to then, we also have works of different scientists like Sir Charles Whitson, who outlined the concept of binocular vision, where you combine two images. We also have, in 1935, the work of the American science fiction, Stanley Weyburn, who published the book Pygmalion Spectacles, in which the main character explores a fictional world using a pair of goggles. So that is the historical background of the metaverse. So in essence, the metaverse is not new. It's been around for a long time. Now, The question that we begin to ask ourselves is, why should the metaverse concern lawyers and dispute resolution practitioners? Like I said, there are various interactions within the metaverse space. People buy land in the metaverse space. Brands are opening stores in the metaverse space. Nike operates in the metaverse. Adidas operates in the metaverse. An avatar wants to go on a date with another avatar. The avatar needs to clothe himself. So brands are supplying these clothes to avatars. We also have the property transactions in the metaverse, where platforms sell properties to users on the platform. But all these interactions generate a lot of disputes. And then that is where we, as dispute resolution practitioners, come in to kind of fashion and design the appropriate dispute resolution mechanism that would fit into the online space and be able to give succor or perhaps remedy to a person whose right has been violated on the metaverse space. Now, the future of the metaverse and the new species for disputes. Just as the evolution of the internet has brought about different kind of disputes, so too will the metaverse bring about a lot of disputes. Like I said earlier, we have intellectual property claims, and as you will see in the later part of my research, a dispute between Nike and StockX that had to do with intellectual property disputes, which is basically StockX using a trademarked logo of Nike. So these are disputes that are capable of arising from the metaverse. And we also have disputes that may involve the user and the platform, where the platform basically devalues the value of a user's land. So such user might be aggrieved from such activity of the platform. Also, we have dispute like dispute against the user and the platform, where the platform it can actually dissolve. The platform can actually also go bankrupt. So what remedy is available to such user whose right has been violated? So basically, I classified the disputes that could emanate from the series of interactions in the metaverse to three. We have dispute against the metaverse platforms. We have dispute against a user and another user, such as intellectual property, sexual harassment claim, and then inter-metaverse disputes, dispute against one metaverse platform and another metaverse platform. So basically, these are the kind of disputes that can emanate from the series of interactions in the metaverse. Now, the question that still stands unanswered is, how will these disputes be resolved, and what mechanism is well suited for their resolution? Does the metaverse platform itself provide mechanisms for the resolution of these disputes, or do the conventional courts have the capacity to resolve this kind of disputes? So these are the questions that I'll seek to answer in the latter part of the research. Now, the metaverse at the moment is not completely ungoverned. We have some legal frameworks that govern the activities within the metaverse space. We have the TOS agreement, the Terms of Service agreement, we have the Community Standard agreement, we also have the EULAs, the End User License agreement. But the basic question is, to what extent are these frameworks sufficiently, or to what extent will they sufficiently remediate disputes that emanate from the metaverse? For me, I would say I don't think they're sufficient, because most often than not, the sanction that they provide for is usually blocking or removing a user from the platform. But there are instances where a user actually requires more than taking away the user from the platform. A user might have suffered a lot of damage. For instance, I give you an instance. Nike, for instance, or a person in the metaverse engages in the sale of virtual landed property, and then another person, another avatar, defames the avatar. The livelihood of that avatar basically rests on its prominence and its reputation within the metaverse space. So automatically, that avatar that defamed the other avatar has taken away his his means of livelihood. So it goes beyond just removing an avatar from the space. And most often than not, again, these legal framework are basically to protect the owners of the platform. They do not really provide remedy to users on the platform. Now, let us look at the recent litigations in the virtual realm. I talked about them earlier. We have McBragg and Linden Lab. So basically, this is a dispute between a Pennsylvania attorney who sued Linden Lab for breach of contract and fraudulent transaction because he purchased a landed property within the Linden lab, and then he was evicted afterwards. So he sued them for criminal conversion and then fraud. Now we also have Nike and StockX. I mentioned it earlier. Nike basically sued StockX for use of its intellectual property because Nike has actually trademarked a lot of marks with the view to enter the metaverse and sell items to avatars in the metaverse. Now, the basic thing or the basic takeaway from these litigations is not actually the fact that they are being litigated, but the basic takeaway is the fact that we're already having a lot of litigations emanate from the metaverse space show that there are potentials for a lot of litigations or disputes that would arise from the series of interactions within the space. And then he also questions the sufficiency of the extant legal framework that we have within the space. That is, to what extent are the extant framework within the space sufficiently providing the remedy that users need, and to what extent are our courts sufficiently equipped with the capacity to resolve these disputes? Now, when faced with a dispute involving the metaverse, as a practitioner, you are approached, an aggrieved user of the metaverse who has an avatar within the space has approached you that, oh, I have this dispute, this competitor has used my mark within the space, my mark has gathered a lot of goodwill, these avatars, thousands of users within the metaverse space are using my mark, this guy has used my mark, what can I do? And then as an attorney, you're faced with certain questions. You begin to question that, okay, how can you actually provide remedy to this person whose right has been violated? What court will have the jurisdiction? What are the applicable laws? Are our courts sufficiently equipped with the necessary skills or with the facilities? Because some of these disputes will actually require evidences, electronic evidences that are in blockchains. Do our courts have the capacity to analyze this evidence? So these are the issues that would naturally agitate the mind of any dispute resolution practitioner. Now, so what are some of the legal impediments to the resolution of the disputes within the metaverse space? Using the conventional courts, there are impediments, there are impairments, there are predicaments that our conventional courts will suffer when they are faced with disputes within the metaverse space. And then the first issue is the issue of jurisdiction. They are faced with the jurisdictional crisis because some of these disputes are actually trans-border disputes because an avatar owned by a user in Nigeria offends an avatar owned by another user in Ohio. So how would the court assume jurisdiction? Because basically jurisdiction is territorial and then jurisdiction is also based on the parties before the court. So the parties before the court must be clothed with the necessary jurisdiction to assume jurisdiction over the parties before it. But one of the avatar, the user of the avatar is in Nigeria and then the other avatar is in Ohio. Then the court begins to question itself. Do I necessarily have the jurisdiction over this matter? And then the issue of territorial jurisdiction as well. They are located in different spaces. And then issue of applicable law. What law would apply? Is it the Nigerian law? Is it the United States law? What law would apply? What body of laws? And then another issue is the expertise of the judges. I'm worried as a dispute resolution practitioner because I don't know the level of prominence that the judge would accord to the evidence that I'm tendering. I don't know what equipment the courts possess to be able to analyze some of these classified and electronic evidence that I'm tendering before it. And then also the fluidity of online identities. It is difficult to identify the parties. Before a court can assume jurisdiction, there must be competent parties before the court. And then the issue of, are avatars actually human beings? Are they persons that courts can assume jurisdictions over them? Or do we actually need to lift the veil of these avatars and go after the persons behind the avatars, the users? So those are basic questions and some of the impediments that would impair the courts to assume or to properly adjudicate over this kind of dispute. And then, of course, the enforcement of the judgments. Any judgment without an enforcement mechanism is useless. Because if you have a judgment as an aggrieved person and then you can enforce it, it's basically useless. Okay, yeah. So now ODR to the rescue. How does ODR come in? What are the things that ODR can bring to the table for the resolution of this kind of disputes? And then all the things against the courts. work in favor of ODR. You would notice that the issue of jurisdiction, the issue of applicable law, the issue of expertise, the issue of flexibility and convenience, they actually work in favor of ODR because all these things are actually embedded in ODR. With ODR, the issue of jurisdiction would not be an issue. With ODR, the issue of expertise would not be an issue because ODR actually equips persons that are well-versed in the resolution of the peculiar kind of dispute that is at hand. So it's basically not before a judge who has been handling matrimonial cases for morning till afternoon, and then in the afternoon you just bring an ODR case before it. So ODR provides us with a platform to equip persons who are experts, who have the necessary skills and competence. Now, lastly, I will talk about the recommendations on how to leverage ODR for effective conflict resolution in the metaverse. And then my first recommendation is a novel online-based dispute resolution model. And then for this, it's a two-pronged model. I recommend a two-pronged model. The first one is establishing a metaverse court system that is similar to the court system that we have, but is basically and totally online-based, where we have metaverse judges and metaverse magistrates to adjudicate disputes that are basically emanating from the metaverse. And then we also have arbitration. So it's going to be a two-pronged system. A system that operates like the conventional courts and then arbitration as well. But they are going to be online-based and then will be completely online. And then also, before we can do this, we need to have an international treaty addressing the disputes within the virtual domain. And this international treaty needs to take care of three things. The jurisdiction to prescribe, that is, make laws that will govern virtual interaction. The jurisdiction to adjudicate would confer on the metaverse courts, the jurisdiction to adjudicate on the dispute, and then, of course, the jurisdiction to enforce that would make such decisions that come out of the metaverse courts to be enforceable in any part of the world, because we are going to have countries who would become state parties to this international convention or the international treaty that would regulate the virtual domain. And then lastly, we have absolute autonomy and territorial sovereignty for the metaverse, recognizing the metaverse as an entity on its own, different from the real world that we currently are at the moment. And then I conclude by saying, there is no denying that the metaverse is a new, bright, shiny object on the horizon, and it is fun to think about where it will lead us. But as dispute system designers and dispute resolvers, we need to prioritize the needs of disputants in any discussion about existing technologies like the metaverse. It may be exciting to play with these innovations and marvel at their richness and power, but if they are of no demonstrable value in helping parties find quick and effective resolution of their disputes, we should set them aside. We need to leverage what we know about the psychological needs of disputants and the neuroscience of disputes to inform us about the true utility of these new tools. If we get wrapped up in idealism about the potential of these new technologies, we may lose sight of our core task, helping people find fair and effective solutions to disputes. Therefore, as dispute system designers and ODR specialists, we have a unique opportunity to be the primary force in setting up a dispute resolution system for the virtual world. The failure of the ODR community to involve itself in the growing debate among legal scholars as to how to regulate and govern the virtual world would represent not only a missed opportunity, but also a tragic abdication of responsibility in contributing to the experience that we have gathered over the years in improving dispute resolution in the real world to the development of a conflict management system in this new virtual space. Thank you very much.
Thank you, Mubarak, for this jump in the future. And the last presentation for this panel will be is Adrià. Please, in 15 minutes.
Yes.
Thank you.
I mean, to give a little bit of relief to the attendees, just so you know, I'm going to set up a timer here to avoid my Mediterranean self to talk too much. But before I do that, quickly, I want to thank the Cyberjustice Laboratory and especially Alexis. Merci beaucoup. That's the only reason that I'm here, that I was selected to give this presentation. And I also want to thank this community for the warm embrace of a newbie like me. I feel like, you know, you guys have created almost a sense of family here, and that's really commendable. Now, There you go, timer. When I came to PRK, and Spiniak took me under his wing, he tasked me with answering not a minor question, which is how to operationalize ethical standards, ODR ethical standards. Now, my logic was that by improving accessibility for vulnerable users, if we focus specifically with vulnerable users, then that would mean improving the building a more inclusive online dispute resolution environment, which at the same time is enhancing access to justice. Now, I believe that ethical standards can be operationalized. It's quite complex, but can be operationalized by finding and concretizing observables through best practices made readily and openly available to all ODR platform designers to implement and be certified by a neutral disclosure assessment project. First off, some acknowledgements, but I had the, obviously, time constraints here, but I could interview some of the attendees here, and that was a really great opportunity. Anyway, so what I did basically, I set up a very long table where on the one side you have a practical indicator, a short description, and then the ICODR standard, as well as the Council of Europe guidelines and standards, which I believe better operationalizes the practical indicator. Then what I tried to do is I chose an array of existing ODR platforms which are known for their emphasis on accessibility, and I tried to compare the compliance of those practical indicators with those platforms. And I can tell you already before the conclusions that what I found is that I believe there is a necessity for a certain kind of standardization. Now, jumping right to the selected few practical indicators that I have for this presentation, and which are interrelated with each other. For instance, we have offline options, right? That seems quite simple. It's just having an offline option responsive to a user request for assistance with the system all the way since the beginning, since the pre-claim to the post-resolution. But what I found is that there is a huge variety of the offline options offered by different platforms. Some offer both a phone call option, some and an in-person physical office, while some only an in-person physical office. And then there's also the question of who should be attending, who should be the operator on the other side. Should it be a human operator? Should it be a non-human operator? But the important thing here for vulnerable users is that there is a step-by-step guidance, meaning that the user is accompanied through the process, which can range from just sporadic help, filling out a certain form, to actually submitting the appeal. But that also raises some other questions which make it more complex, which are your soft opt-outs and your hard opt-outs, meaning where can you, in favor of accessibility, change some of your procedure, and where do you draw the red line? Now, these operators obviously have to be sensitivity trained. That's what I mean with the interrelation between the practical indicators, right? They have to be sensitivity trained to digital illiteracy, to many kinds of disabilities. Just a little test result here, a little experiment that I perhaps was not very in the realm of ethical research, but what I did basically, I don't know if you know about this, but there's this, well, obviously you would know. There's this ODR consumer protection set up by the European Commission that we have in Europe. And I tried to pose as a digitally illiterate person and in need of assistance, calling to 4 different countries. Actually, it was 5, but Italy never responded to the phone during 3 days. But in any case, I called Ireland first, And what I got was, by the operator, a really unempathetic response to my hypothetical situation. And then right away I got a hard opt-out saying that since I was not a resident or a citizen of Ireland, he could not help me and even less guide me step by step through the platform, which is not entirely true, because it could have been the case that the company that I was having a contract with would be a company registered in Ireland. Then I got Spain, and I got a bit of more of that Mediterranean empathy, but still not sufficient, and also a refusal to guide me step by step. Then I got Iceland, which is not the European Union, but the European Economic Area, so the regulations regarding consumer protection do apply there. And surprisingly, I got the option to be guided step by step throughout the process, no matter if I was a resident or not. And then finally, I got the Czech Republic, and it was absolute bliss. The operator actually seemed to be trained specifically for this kind of situations. And after I revealed my true identity, the Irish operator said that they never had any kind of sensitivity training. The Spanish operator said that he only had some anger management about 6 years ago. The Icelandic operator said that they did have some training on how to deal with stressful situations over the phone. And what's most surprising is that the Czech operator said that he did design a set of guidelines on how to act in these situations with vulnerable users, but this was on his own, by his own decision, and for his own department, so nothing official. Now this to me just shows a certain need of standardization, because of practical standardization, because in this case we're talking about the exact same platform, but different reactions, right? Completely different scenarios. Now, the importance again of plain and empathetic wording. Here we can bring about the so-called Canadian model, right? We have the CRT with which acknowledges vulnerabilities, which is a really good step because it creates a sense of comfort. The Traffic Penalty Tribunal in England does the same. And then things like suggestion of the third non-party helper. That's also a core measure. That's not really a budget or time constraining thing to implement in an ODR platform. It's just saying, well, we understand that it can be hard sometimes. If you're alone, you may contact someone else, and so long as you understand that he can do these things for you, but not these other things, then you're fine. Then things like awareness and first contact, right? Obviously here we do find very big, huge differences in terms of budget, in terms of PR, in terms of you can do, especially between private and public ODR platforms. But there are many, you can, the physical court could direct the prospect litigants to the ODR platform. There could be intermediaries or trusted agents in a community that already know where are the vulnerabilities and the vulnerable users, how to address them, how to direct them to the platform in the first place. Because you can tweak a platform however you want it to be more accessible, but if they don't even get there in the first place, then you're lost. But then again, obviously, it's quite hard to quantify how much this happens. Now, all of this can be assessed in terms of presence or absence, existence, most. Then a big one, assistive technology. These basically are tools for counteracting certain disabilities, and this is quite actually simple to assess in terms of compliance. There are the World Wide Web Consortium guidelines. The e-TOIMIC in Estonia, for instance, is a really good example because it's built on those accessibility guidelines. Translation options, right? You can use your own software. You can at least tweak the platform so that it is compatible with Google Translate. And then an interesting one, and I guess this is a good example of what I will mean by a flexible certification system. Here, again, this is sort of a Canadian model kind of thing, But it's very useful for vulnerable users to have a step-by-step demonstration of how to use practically the platform, and that should be end-to-end, so very complete. And there are many outside of Canada courts that are doing that. eToimic is doing that. The Ombudsman for Retail, for Consumer Protection in Belgium is doing that. The TPT is doing that. And then I found this, I think, quite exemplary case, Webnier. I'm always butchering the name, but they're from India. And they offer to schedule a demo where you can run through the platform with an operator and see by yourself, with their help, how the whole thing works. Now, there's just great examples by the CRT and eToimic. Then, throughout these panels, we talked a lot about data and how you gather data. I guess here I can't really add anything to it other than it's important to have vulnerable users included in the pre-testing phase and as much as possible. And then obviously it would be interesting to identify where are the vulnerable users in the user evaluation, so then you can do some focused tweaking and nudging. There's a certain hot step of the process where people take too long. What's happening there? How can we look at that, right? How can we make UX and UI design more aesthetic, more appealing? That's also quite important. Again, talking about comfort is also talking about accessibility. And another practical indicator that came up with is this thing called the through and through front page. Quite simple. It's just also flexible because you can then have room for having the web page however you want it, but it would be very useful just to have very clearly in a click once disposition where are the contact options, where are the accessibility tools, where's the user map, and then obviously the solution explorer to start the process. The solution explorer, the problem solving wizard, here we can talk about AI, we can talk about this choice-based user experience that Dr. Ayelet talked about, Zbigniew is also pushing through. But here the important thing is that it really, having a solution explorer really eases the entry of the vulnerable user into the process and can accommodate their accessibility needs. Now, so in conclusion, there is what I called complexity of total accommodation, right? It's very hard to have a set of practical indicators that can be followed. But I think that if we want to have a first step towards open source ODR, like Zbigniew talked about, we could start by trying to have a practical guide, a practical layout of those standards that have been already achieved, and now, so glad the ICO is looking into them, to include them. If an ODR designer can have it at the ready, can have it listed, then, I think we can identify some core measures. We can then differentiate between public and private ODR. We can rate according to budget. We can discuss who should be the measurer. In my opinion, it would be iCoder. But with that, you can really transition from the aspirational into the practical. And I guess I'm going to leave it here. I think I'm pretty good on time so that we can have some more discussions, because I'm really interested in knowing what do you think about, especially who should be the measure, how many stakeholders can we bring into the table, and yeah, that's it for me. Thank you.